Hmm. Hmm. Okay. Is that? I think that's working. Let me check. Test. Yeah. Okay. Minimize that. Okay. Okay. What are we doing? Let's do. What are these? What are these? Torts. Reading cases effectively and finding and citing cases. Okay, let's do torts. Tort law in 2 hours. That is the plan. Lore. You note. Torts. Okay. Okay. How many more? Hold on. We've done contract, constitutional, admin, maybe. No, I think those are the only things we've done. Criminal? No. Let's do torts. We'll do torts. And then just go down the list of the ones that we haven't done. So torts, negligence, preparing for law school. That might be interesting. I don't know. Yeah, we'll see what that. I'm not preparing for law school, but maybe it'll have some interesting tips in there. Criminal law and corporations, and then this is going to serve as our foundation. But this, there's a few other links here which are really, really, really good. Like the one on finding and reading cases, super, super important, because I actually want to read a couple of cases, especially around the hate speech bill. I think there are a couple of cases that I had written down somewhere to follow, because it might take years for that to actually have a resolution. But yeah, I would like to read a few cases and actually try to understand something. I understand the arguments and the rulings and the ruling. But let's start with torts. I mean, today let's continue with torts. Hour and 43 minutes. Okay, let's see how hard this is going to be. Like, I really enjoyed constitutional law. Contract law was quite dense, not confusing, just dense. Okay, and stream isn't getting that sound. Why? Properties. Tort law. There we go. It's a little bit louder.
G'day everyone.
Wow.
Anthony Marinak's my name.
Wow.
And welcome to the second of my 2
The
hour
volume of
law
that
courses.
just.
As with the previous one, the idea here is to gallop through.
Okay, hold on. Let me put a limiter on the application audio so that doesn't happen for you guys next time. Limiter minus 60B. Yeah. Okay.
An entire university law course in 2 hours. This time, we'll be looking at intentional torts. Now, most of you in most law schools will find that your study program
Turn down a little bit more.
Includes two torts courses. They might be called Torts A and Torts B, or Torts 1 and Torts 2. But you generally find that one of those courses is all about what we call the intentional torts, and the other one's about negligence. I'll describe the difference more once we get underway. I'm hoping that a future 2 hour law
Okay, I think that's a decent
course will be done on negligence.
level.
Now, as I said at the start of the previous
This volume is changing a lot, though.
2 hour law video, these videos are a great way to get an overview, and they're great for revision. But we're doing this in 2 hours here. Obviously, the detail is heaps less than what you'll get by studying each week at uni. So this video can help, but it can't replace an entire detailed course in tort law. Finally, as always, along the bottom of the screen, you'll find the statutes and cases which support the points of law that I'm making in my description. Take a note of those, and you can go looking for them to help fill in the details. The law discussed in this video is Queensland law, but torts is very similar throughout Australia, and I've done my best to illustrate those areas where the law in other states is different. I understand the law to be correct as at the 30th of June 2018. Alrighty, 2 hours. I'm up for the challenge again. Let's start the clock. Every torts course in the whole world starts out by telling you that the word tort is a French word meaning wrong. It's also customary to make a joke about how a tort is also a rather yummy cake. So a tort is something that a person does wrong to another person, with the result that the victim can sue them for a remedy. Now that's a simple enough explanation, but it's not an altogether helpful one. I would prefer to say that everyone in our community has a bundle of interests. We have an interest in our own body, for instance. We don't like it when others hurt us or touch us without our permission. We have an interest in our own stuff. If we own things or possess things, well, others shouldn't use them or take them without our agreement. We have an interest in our land. We don't want others coming into our homes or onto our lands without our permission. We have an interest in our reputations. We don't want others trashing us. We have an interest in fair economic transactions. We don't want to be ripped off. We sometimes have an interest in other people. We have an interest in the communal environment in which we live, and we don't want others harming that communal environment, especially where that directly affects us. Now, once upon a time, back in the Dark Ages or something, if a person harmed us, then we'd probably take it unto ourselves to go and do something about it. We might steal our stuff back, or challenge them to a duel, or stab them in their sleep, or set their house on fire. All very satisfying stuff. But the rule of law is supposed to create peace, order, and good government. So the law has to provide people who have been wronged with things they can do about it without burning one another.
Provides a lawful way for people to seek remedies when they are harmed.
Others' houses down. That's tort law. Tort law says, here are a range of interests which the law will protect. If someone messes with those interests, you can sue them and obtain a remedy. Now, some of you will straight away see that tort law overlaps with some of the other types of law that you'll most likely be studying in your first year of law school. For instance, if someone was to physically harm you, or if they were to steal your stuff, then they'd be committing a criminal offence as well as a tort. In the same way, quite often, a person who commits a tort against you might also be breaching a contract with you. For instance, if you put a beautiful dress in to be dry cleaned, and then saw the dry cleaning staff member wearing your dress at a social function, well, they'd be committing the tort of conversion, but they'd also potentially be breaching your contract. The cool thing is that where these causes of action overlap, you don't have to choose. Both remain open. So let's say someone does hit you, and as a result, you end up with a big dentist bill. Well, the police might charge them with a criminal offence, but that criminal offence is between the Crown and the defendant.
Oh. Okay. Okay. Put this down here. Okay. So the police would charge, so they would be committing a crime and a tort. Police would charge them with a criminal offence between the Crown and the individual. That's what he said, right?
You as charged does hit you, and as a result, you end up with a big dentist bill. Well, the police might charge them with a criminal offence, but that criminal offence is between the Crown and the defendant. You as the victim, well, you're really just a witness for the prosecution. Under tort law, though,
Hold on. I was typing.
You don't have to choose. Both remain open. So let's say someone does hit you, and as a result, you end up with a big dentist bill. Well, the police might charge them with a criminal offence, but that criminal offence is between the Crown and the defendant. You as
Well, yeah, defendant. Dant?
the victim, well, you're really just a witness for the prosecution. Under tort law, though, you can still potentially sue for damages for the harm they caused to you.
Ah. Huh. Interesting. Okay. So right. Okay. And in this scenario, you are just a witness for the Crown.
We'll look more at the detail later, but for now,
Witness.
just understand that tort law often does overlap with other areas of law, and that's okay. The victim will generally have access to both.
Well, I wonder. So would both of these? Well, okay. Like, I can Say, I guess you'd probably want to have. Well, if you thought that the evidence was in your favor, you'd want the police to, or the Crown to, make their case first, right? Because maybe when you're suing for damages, you can rely on what the Crown, found, or arguments that the Crown made. So basically, they'll be doing some of the work for you. Or maybe, or I wonder if you didn't think that the Crown was going to make a good enough case, or you wanted to help them. I wonder if you would do your case first, hire a super expensive law firm, right? So that the Crown could rely on things that your lawyers have, arguments your lawyers have made, or witnesses, or interesting, because it could be confusing for the lawyers if both of these cases are tried simultaneously, because maybe there'll be the same witness for both cases. Interesting. Okay.
We traditionally divide torts into them. The tort law often does overlap with other areas of law, and that's okay. The victim will generally have access to both.
But when he says the victim will generally have access to both, but really it's the police. I don't know how the victim has access. Well, I guess I guess they go to the police. If the victim would go to the police and say, "Hey, look, I'm willing to be a witness for this," and lay it out, and then the police would decide whether or not they want to charge. Interesting. Okay. Yeah, it'd be interesting to see how this actually plays out in reality. Okay. Types of torts.
Traditionally divide torts into what we call intentional torts and negligent torts. Intentional torts, which are the ones we're discussing in this video, require a certain level of intention to commit the act or the omission which results in the harm. Negligent torts, on the other hand, don't require intention. Negligence occurs when a person has a duty of care towards someone else and they fail in that duty and the failure causes harm. For the intentional torts, there are a few fundamental things to think about. First, the law is only interested in whether the person committing the tort, we call them the tortfeasor, intentionally committed the act. The law isn't usually interested in whether they intended the harm that followed. So let's say I threw a rock.
Okay. Okay. That's an interesting... Did the person intend the act? Not necessarily intend...
You're usually interested in whether they intended the harm that followed. So let's say I threw a rock in your direction to give you a bit of a scare, but my aim is the act. The law isn't usually interested in whether they intended the harm that followed. So let's say I threw a rock in your direction to give you a bit of a scare, but my aim was off and I clocked you between the eyes. Well, that'd still count as intentional. There are a couple of torts where this isn't true, and I'll mention those later. But the basic principle is that we are only worried about whether the act was intentional, not whether the harm was intentional. Second, it's sometimes enough to be reckless. So let's say I was at a concert and there were a bunch of people there with phones, but just to be smart, I was spraying people with a water pistol. I might not have intended to spray anyone's phone, but I knew it was a pretty solid possibility and I didn't really worry about it. In some cases, recklessness might theoretically be enough for the act to be intentional. But most recklessness cases are more likely to be sued as negligence. Without an intentional act of some kind...
interesting. Okay. And I'm sure we'll understand more why once we get to the negligence video. But example, person spraying water on a crowd in a concert, causing damage to phones.
You usually don't have an intentional tort. Finally, one of the beautiful things about studying torts is how structured they are. Okay. For this reason, any of you who enjoyed criminal law will almost certainly enjoy torts as well. Every intentional tort is broken down into a number of elements. We're going to go through those elements for every intentional tort. To work out whether an act was tortious, that is, whether it's a tort and whether it gives rise to liability, all we need to do is break the tort down to its elements and look for evidence to show that those elements are present. From a conceptual perspective, it's dead easy. There are a few things I want to look at briefly before we get stuck into the individual torts though. First up, anyone who knows my teaching knows that I'm a sucker for a bit of history. You can't understand the law without understanding its history, especially tort law. You see, tort law is some of the oldest law we know. The very oldest written laws that we know about are the Code of Hammurabi, king of the Babylonians. Now, these laws were written nearly 4,000 years ago, and most of them are basically tort law. For instance, law number 245 says, if anyone hire oxen and kill them by bad treatment or blows, he shall compensate the owner, oxen for oxen. In other words, if you damage someone else's stuff, you're going to have to compensate them. Now, the Romans, who are much more likely to have provided a basis for our English-based system of law, they produced the Lex Aquilia. That's a system of laws which was also about compensating people for damage unlawfully inflicted by the defendant. In our terms, by the tortfeasor. So you can see, for thousands of years, laws have looked for ways to provide compensation to those who are harmed by the unlawful actions of others. In the English system of law, this resulted in what was called the writ of trespass in the old writ system. This writ first came on the scene during the 1200s, so in the same century that Magna Carta was signed. So again, very old. The writ of trespass allowed people to claim compensation for interference with a person or their goods or their land. The legal fiction was that the tortfeasor, by engaging in this interference, had interfered with the king's peace, which is why the courts could get involved. In reality, the courts were more likely involved to prevent breaches of the peace which would occur if people just sorted it out for themselves by burning one another's house down. And second, the courts wanted the income from the fees paid by those bringing cases before the courts. Over the centuries, another writ developed, referred to as an action on the case. It's a very odd description. And this writ was used when the harm was caused by one person to another, but where they couldn't necessarily show a trespass. This writ ultimately became the tort of negligence. In any event, you can see that tort law is truly ancient. And despite the passage of thousands of years, it still basically does the same thing it's always done. It requires tortfeasors to compensate their victims for interference with their protected interests.
Okay.
In recent years, though, parliaments have really changed the game when it comes to many types of tort. I know you're probably busting for me to start talking about the actual torts themselves, but bear with me, this bit really is important. You see, there are a bunch of different situations where one person might cause harm to another, and where the victim of that harm might be able to claim compensation or other forms of support under a parliamentary law or a statute, rather than relying on general tort law.
Okay. So this is sometimes, or areas where the victim sometimes the victim can rely on a particular statute instead of tort law. Examples.
So it's important to be...
What's the difference between a statute and an act? Statute versus act. Australia. Oh, they refer to the same. Legislation passed by the Parliament. The term act specifically don't... An act is a statute or law. What's the difference between a statute and a law? An act. Because there's a criminal... We've looked a lot at the criminal code volume. I forget, all 3 volumes. And I guess those have laws in it. Okay, and statute. A statute is another term for a law, legislation, or collection of legislation. Statute book is generally a reference to all legislation that is in force at a particular point in time. Okay. Let me just go down to L rather than that. There's none for law. The term legislation can refer to a single law or a collection of laws. Okay, I'm not really sure what the difference is, but essentially it's all referring to stuff that is passed by the Houses of Parliament. Legislation passed. I don't know why there is a difference. Let me change my hold on. Let me turn this up a little bit. Test, test, test. I want that to go a little bit there. There? Okay. And close that. Sound settings. Advanced. Great. That's going to turn down the monitor for me. Test. Okay. Good. All right. Okay.
Aware of these.
Okay. It's all referring to legislation passed by the Parliament.
Up front, because the last thing you want is to be rushing off to use tort law when in fact there's a statute which provides your client with a different scheme of compensation.
Yeah. Okay.
So let's look at some. All states in Australia have established legislation requiring the operators of motor vehicles to have third-party insurance relating to those motor vehicles. That insurance covers the damages to some other person, the third party, if your car injures them in an accident where the driver of your car is at fault. These schemes include simplified, more efficient procedures for resolving disputes about those claims. In addition, there's a national scheme called the National Injury Insurance Scheme, which provides support to those seriously injured in motor vehicle accidents, regardless of who's at fault. Now, neither of these schemes actually stops a person from taking action under traditional tort law, but they represent such an improvement that virtually every traffic accident is resolved under the legislation.
Okay. Now he's saying scheme. What is the difference between why include scheme there? Just to confuse me, I guess. Okay. So these don't stop the victim having access to suing under tort law, but and so
virtually every traffic accident is resolved under the legislation.
Virtually every traffic accident is resolved under this legislation. I wonder why that is. Because, like, suppose you get... Suppose there you we'll have to read what this is, but there's probably some thinking there against double dipping for remedies, right? Because, like, suppose you got a remedy for getting injured, under the National Injury Insurance Scheme, and I haven't read this at all. And then you try to sue under tort law. Maybe the court would be like, "Hey, well, you already got this remedy. You have to make the argument for why the remedy wasn't sufficient." Maybe. Okay.
If a person is injured in their workplace, then in a similar way, their compensation, the costs of their treatment and rehabilitation, and the process of returning them to work is all now managed via a statutory scheme in each state and territory. The scheme is funded by employers who are required to maintain appropriate insurance arrangements.
Oh my God, I can't spell. I can't. Act 3. Oops.
Scheme does not actually prevent people from taking action under traditional tort law. The scheme is generally so much better that virtually everyone stays under the legislation.
Okay.
All states have established victims of crime support schemes. In Queensland, the scheme is operated by a government
Victims of crime.
An entity called Victims Assist, and it provides compensation to victims of violent crime. It doesn't provide the same sort of compensation for victims of non-violent crime. The amounts payable are capped, usually at $75,000, and the government itself then goes after the offender for the repayment of that money. So the advantage is that victims don't have to go to the time and expense of legal action while trying to fund their recovery in the meantime.
Right.
The disadvantage is the limitation on damage. However, again, this legislation doesn't stop people from also taking action under tort law. Next, there's a joint Commonwealth state scheme involving all the states and territories called the National Disability Insurance Scheme. This actually isn't an insurance scheme at all. It's funded by the Commonwealth and the state.
So, okay, so they can only choose... So it seems like they can only, in this case at least, you can only choose one or the other. Because, like, I wonder if you could go for get the victim's assist, even if it's capped at 75k, and then once you've recovered, go to court for the other, for whatever you can get under tort law.
State governments, and ultimately it's funded by the taxpayers who earn enough that they're required to pay the Medicare levy. Essentially, the NDIS exists to provide necessary and reasonable supports to people with disabilities. This includes people with congenital disabilities, but also people who have disabilities which come about because of the actions of others. So the sorts of things we normally think about in the area of torts. Now, the relationship between the NDIS and tort is a little different because a person receiving support under the NDIS can actually be required to take action, including under tort law, to obtain compensation for whatever's caused their disability. That compensation money then goes to fund their NDIS support. Finally, the Australian Consumer Law, which applies right across Australia, contains provisions which allow consumers of goods and services to obtain compensation and other remedies if the goods and services don't work, or more importantly for our purposes, if they end up actually causing harm. Now, these consumer provisions are much more relevant to negligence, which is the other half of torts, but I still want you to know that legislation's out there. So overall, you can see that the parliaments in Australia have been quite active when it comes to reforming areas of the law relating to the provision of compensation for people who've been harmed by others.
Well, he said here it doesn't stop the, at least for motor vehicle accidents, it doesn't stop the victim having access to suing under tort law, but virtually every traffic accident is, maybe it's, he was saying here it's either, it is or, having access to suing under tort law at the cost of not relying on the statute. Does the any area prevent the victim from seeking a remedy under both the legislation and tort law?
The tort law we're going to be talking.
Be right back real quick. Okay. Schemes of
This
compensation.
lecture has to exist in harmony with those other schemes. All right, enough of the preliminaries. Let's get stuck into some torts law. At the outset, I said that one of the purposes of torts law is to compensate people for various types of interference. The first of those types of interference we're going to look at is interference with the person themselves. In many texts, you'll see this referred to as trespass to persons, which is language harking back to that old writ of trespass. Interference with the person starts with a fundamental philosophy that the law should absolutely protect each individual person. Referred to as trespass to persons, which is language harking back to that old writ of trespass. Interference with the person starts with a fundamental philosophy that the law should absolutely protect each individual person.
Okay.
Nobody should be allowed to touch you or take actions which hurt you unless you consent or unless they have some other lawful justification. There are 3 torts relating to interference with a person. They're called assault, battery, and false imprisonment. They each require a number of the same elements to be present. First, they each require a voluntary act. This means the tortfeasor must intend their conduct. So to take an example...
Okay. So if someone hit someone else but they were compelled to do so, that wouldn't be a tort. That person wouldn't be liable because they were compelled for some reason, right?
From the cases, if a person is having a medical fit,
voluntary. Medical. Actually, that's a way better example. Voluntary act.
They strike somebody through the spontaneous action of that fit. It's not a voluntary act. Second, the voluntary act needs to have what we refer to as an injurious effect. So it needs to cause some consequence that the law will protect. Now, as we go through each tort, you'll see that the injurious effect changes for each tort. The injurious effect has to immediately follow on from the act. So if there are intervening actions, like a chain of events, between the act and the injurious effect, there's probably no liability. Finally, for these torts against the person, it's necessary to either intend to cause the injury, or alternatively, the tortfeasor, the wrongdoer, needs to be reckless as to the injury.
And we've already got intention and recklessness up here. Oh, is it or reckless?
Basically, a tort against a person occurs when one person performs a voluntary act which has an immediate injurious effect upon another person, and where they intended the injury or were reckless as to the possibility of the injury. Let's start by looking at assault, because assault is not actually what most people think it is. Assault is the intentional offer of a threat of force or violence to another person who reasonably believes that the violence will be carried out immediately. Assault. Because assault is not actually what most people think it is. Assault is the intentional offer.
The intentional offer?
Of a threat of force or violence to another person who reasonably believes that the violence will be carried out immediately.
Reasonably.
So assault doesn't require any touching at all. Assault is about the threat. And you can see why. If I point a gun at someone, well, they're entitled to be terrified. And they're entitled to the law's protection from that terror. And that's the case whether I intend to shoot them or not.
Oh, right. Huh. Um. Hmm.
Let's break down what we mean by assault. The first element we need is an intentional offer. How might this happen? Well, there are two ways, through words and through conduct. So if I shouted at you, I'm going to punch you, then that would be an intentional offer of that threat.
Hmm.
Similarly,
Must not be conditional. Okay.
if I said nothing but I shook my fist at you in a way that made it clear that I was about to hit you, well then that too would be an intentional offer. More often though, words and gestures happen at the same time. And those words and gestures can actually affect one another. So for instance, in an old case called Reed and Coker, the plaintiff was surrounded in a workshop by the defendant's workmen, who told him to leave or they would break his neck. You can see in that case the words and the actions went together. So there was definitely an assault. In another, even older case, though, the defendant, having been provoked by the plaintiff, laid his hand upon the handle of his sword and said, "If it were not a seize time, I would not take such language from you." In other words, the circuit judges were in town, so it was the worst possible time to be killing someone in a duel. And so while his gesture was threatening, can you see that his words actually undid the threat? He was saying, "I'd really like to pull out my sword and cut you in half, but because the judges are in town, I'm not going to."
Huh.
So there was no offer of a threat, and therefore no assault. The second element is that there needs to be a threat of force or violence towards the other party. So if the threat is something other than force or violence, it's not an assault. One of the more interesting examples there is a threat to take a photograph. The other person might not want their photograph taken. It might be a threat of something unpleasant, but it's not a threat of force or violence, so it's not an assault. The third element is that the other party has to reasonably believe the threat can be carried out. If someone makes a threat towards you and you don't for a moment believe they could carry the threat out, then it's pretty hard to suggest that the threat has caused you any particular terror, isn't it? Bear in mind the key word reason.
Imminent carrying out reasonable beliefs.
Reasonably.
Imminently doesn't mean immediately. Imminent definition. Threatening to occur immediately. Bent upon, attentive to. Happening soon. Okay. Occurring at once, happening without delay. Okay. What?
So the question here is not whether this particular victim believed the threat could be carried out, but whether a reasonable person would have believed that.
Okay, yeah. Reasonable person would believe the threat can be carried out, not the victim. But I think it's a reasonable person. Yeah, well, it's a reasonable person in the shoes of the victim, right? From the perspective of the victim.
The classic case here is a pistol, which might not even be loaded, being pointed at a victim. Well, the reasonable person in that situation would fear the threat was likely to be carried out. They can't be expected to have any idea whether the weapon was loaded. The final element is that the victim has to reasonably believe the threat can be carried out imminently. but what we mean by imminently is a bit fuzzy. It doesn't have to mean immediately in the sense of the next few seconds. However, the threat does have to immediately play on the victim's mind, and there does have to be a certain continuity between the threat and the likelihood of the violence. However, the threat does have to immediately play on the victim's mind.
Immediate?
And there does have to be a certain continuity between the threat and the likelihood of the violence.
What do you mean? Okay. Okay. And continuity between the threat and likelihood of violence.
However, the threat does have to immediately play on the victim's mind. And there does have to be a certain continuity between the threat and the likelihood of the violence. So, for instance, in Zanker and Vartokis, the defendant had trapped the plaintiff in his car. He'd unsuccessfully...
Okay, this might be one that I would like to read. 1988. 34A, Crim R11.
Demanded sexual favours from her, and then speeding along, he said, "I'm going to take you to my mate's house. He will really fix you up." Now, even though that threat might not have been resolved for another 10 minutes, half an hour perhaps, it immediately cast terror upon her, and she was stuck in the situation with no prospect of escape in the intervening time. That was an assault.
Okay.
The essence of assault, though, is threat and apprehension. Once the force and violence becomes real, you got yourself a battery. A battery.
Okay. Once the threat of force or violence becomes real. Okay.
Battery is an act which intentionally and directly causes offensive physical interference with the plaintiff's person. Now, we've already talked about what we mean by intentional, and we've already talked about what we mean by direct. So let's assume those two are covered off. The third element we need to look for in a battery is offensive physical interference. Notice how it doesn't actually require harm. It doesn't require pain or bruising. In fact, the form of words used is that the least physical touching can constitute an assault. The slightest brush of a defendant's fingertips against the plaintiff can be enough to cause offensive physical interference. Now that makes a lot of sense because the law doesn't just want to protect us from being harmed. The law says that we are each inviolable. Each of us gets absolute protection of our bodies. We get to decide who touches us. And if someone touches us in an offensive way, it matters not that they did not inflict some physical harm. And yet, touching is also a very normal part of our social engagement with people, isn't it? I mean, by going out into the community among other people, we kind of accept that under certain circumstances we might touch and be touched. Someone might touch you on the shoulder to attract your attention. A complete stranger might reach out and grab you if you're about to fall. Getting on the train or going up to the bar or sitting next to someone on an aircraft, these are all situations in which we generally accept that some level of social touching is going to occur within certain social boundaries that we all tend to know. The law says that this social touching does not constitute a battery because it's not offensive. But even this sort of touching, normal social touching, might become offensive if the person touching continues to do so even after the other person has made it clear that they're uncomfortable. Touching someone to get their attention becomes offensive if they've made it clear that they do not wish to give you their attention. This in turn means that the notion of offensiveness might be different in different cultural contexts. For instance, as a man, for me to physically touch a Muslim woman might for her be an offensive contact because of religious rules. In the same way, for a woman to touch a Buddhist monk would automatically be offensive. If you knew that your touch and the nature of your touch was going to be offensive and you went ahead and did it anyway, that would definitely be enough to constitute battery. The final thing to note is that while the action must be direct, that doesn't mean that the tortfeasor must actually touch their victim. Using an implement, or throwing or firing or launching a missile of some sort is just the same as striking the blow personally.
Okay.
Shining a bright light or a laser pointer in someone's eyes would be just the same. If you've directly caused the contact, that's enough. The last element is that the interference has to be with the plaintiff's person. Now that doesn't say the plaintiff's body. Contacting, for instance, their clothing or something they might be carrying would also be enough. You can't get out of battery by making a sneaky argument like, I didn't hit him, I only hit his shirt. In the case of Purcell and Horn, Horn's wife Elizabeth threw a bucket of water, the complaint said boiling water, over the plaintiff. It ruined his greatcoat, and he was able to sue her as a trespass to the person, not merely a trespass against his goods. The third of our torts against
carrying
the person is what we call false imprisonment. Bit of an odd title.
Okay. Assault, battery. False imprisonment.
Really, because there's nothing false about the imprisonment. Really, we should call it something like improper imprisonment, but you get the idea. False imprisonment is an intentional and direct act, there's those words again, which causes the total restraint of the victim.
Let me make these numbers instead. Okay, so really this is going to be our sort of contents. And we'll make all of these a heading 3, and all of these are heading 6. Okay.
Within an area defined by the tortfeasor for any length of time. All right, let's break that down. Again, we're going to skip over intentional and direct, but if you're looking at false imprisonment for a problem question or for a client, you'll definitely need to be looking for an intentional act which directly causes the false imprisonment. So the third element then is the total restraint of the victim. What do we mean by this? Well, for starters, we don't necessarily mean that the victim must be bound hand and foot. What we mean when we talk about total restraint is that they have been secured in an area from which they cannot leave. So, for instance, in a case that we've already met, Zanker and Vartokis, she was locked in a moving car and the door handle on the door was not operating. So she'd been trapped.
But even if the door handle was operating, if the car is... Like, if the car is driving at 100 kilometers per hour, right, and the door handles are operating, couldn't you argue that the threat of, the risk of hurting yourself while leaving constitutes false imprisonment? Because, yes, while there is another way to leave the car, it's not really a safe way to leave.
It's a way out for the person, even if it's not a way out they would leave. She was locked in a moving car and the door handle on the door was not operating. So she'd been trapped. If there's a way out for the person, even if it's not a way out they would like, well then it's not false imprisonment. So in Bird and Jones, the plaintiff was prevented from moving through a public park because part of it had been roped off for paying spectators of a boat race. He was allowed to go in any other direction though, and so there was no imprisonment.
Hmm.
Similarly, in Balmain, New Ferry and Robertson, the plaintiff, Robertson, was held not to have been falsely imprisoned on a wharf in Sydney because he realistically had the option of swimming the short distance from the wharf to the nearest point of land if he truly wished to avoid paying to make his way through the turnstiles. The fourth element, confinement within an area defined by the tortfeasor, really falls out of that.
The victim need not be aware.
That discussion of total confinement. If I am confining you, then part of what I'm doing is establishing the boundaries of how far you may travel, whether it's keeping you in this car or this room or on this wharf or in this plane. If the tortfeasor can't define the area that you must remain within, then it's quite likely that you're not in fact totally restrained, isn't it? The final element is for any length of time. Now this is really important. False imprisonment might in fact occur for just the briefest moment. If there is any period of time in which the victim is not free to leave, then they have been falsely imprisoned. One last thing with false imprisonment. Strangely enough, it's not actually necessary that the victim should know at the time of their imprisonment that they're being imprisoned. In the key case, Mearing and Graham White Aviation, the plaintiff was being interviewed by his employer in a closed office, and he didn't know that there were big burly staff members posted outside to stop him from getting away. Can you see how he's been falsely imprisoned? He had no realistic way of leaving that room if he wanted to. And yet at the time, he had no idea that he was being imprisoned. Now, obviously, the victim would need to find out later, or else why would they bring the action? But at the time, they can be blissfully ignorant. So those are our three torts in the category of interference with the person. Assault, which is based on a threat. Battery, which is based on offensive physical contact. And false imprisonment, in which a person's liberty is taken away. There are a number of defences open to a defendant accused of these torts, but the tricky thing is that the burden of proof swaps over. So the defendant must prove, on the balance of probabilities, that the defence applies. Let's look at those defences briefly now. The first one to look at is consent. You see, sometimes we do consent, particularly to battery. Anyone who's ever stepped onto a football field or taken a karate lesson or had a massage or visited a doctor has most likely consented to types of touching or force which go well beyond normal social touching. But they're not torts in that context. Because there's consent. Next, there is necessity. Now, this defence applies if the actions of the defendant were reasonably necessary for the preservation or protection of life, and if the plaintiff was not able to give or withhold their consent. This classically occurs in a situation of a medical emergency such as a car accident. However, if the plaintiff's lack of consent is known, necessity will not apply. This happened in Millett and Shulman, a Canadian case in which an unconscious patient was carrying a card stating that she was a Jehovah's Witness and she did not consent to blood transfusions. A transfusion that was given to save her life was still an assault.
Right.
Next, there's self-defense. You can rely on self-defense in defense of yourself, in defense of others, and in defense of property. But the force you use has to be no more than reasonably necessary and not out of proportion to the threat. You also can't go one step further and cross the line into retaliation. The next defence, discipline, is of course very controversial. A parent, a school teacher, or the captain of a ship or aircraft may use force or cause force to be used in pursuit of their disciplinary powers, provided the force used is no more than reasonably necessary in the circumstances. So the force which might be used in relation to a young child by a parent might obviously be less than the force that might be used to stop a 16-year-old child from fleeing home in order to meet their drug dealer. The final defence is lawful authority. This has a couple of aspects. Most obviously, a police officer executing their powers of arrest or an authorised person detaining somebody under an involuntary treatment order for their mental health. would have very specific legal powers to engage in conduct which, in the absence of those laws, would be assault, battery, or false imprisonment. Second, as you'll find when we look at interference with land and goods, certain torts allow people to engage in self-help. For instance, by entering premises to take back their own goods which are being withheld from them. In those circumstances, the person engaging in self-help will be entitled to use force, but not to such an extent that they cause grievous bodily harm.
That's interesting.
Okay, the next major category of tort for us to discuss.
Okay. Obviously, this is just a light overview.
Is the category.
But yeah, cool, interesting. Interference with goods, right? Put this here. Conversion. Detinue? Okay. Detinue.
Of interference with goods.
So, voluntary act by the tort feasor, so similar to interference with the person, which directly interferes with the plaintiff's possession of goods. Okay.
You'll sometimes see this referred to as trespass to goods or trespass to chattels. Now, before we really start looking at the torts themselves, there are a couple of concepts that you need to wrap your head around. If you've already done property law, you'll know all of this. Now, before we really start looking at the torts themselves, there are a couple of concepts that you need to wrap your head around. If you've already done property law, you'll probably know all of this, but a refresher is not going to kill you. There are two key types of relationship that a person might have with an object: ownership and possession. Now, very often they're the same. I own something and I have it in my possession and it's mine. But there are also lots of occasions when ownership and possession are separate.
Let me go back. Goods in your control, like borrowing a car, would be possession but not ownership. Constructive possession, the goods are not actually on you. So someone, damaging something you own in your house while you're away.
And it's mine. But there are also lots of occasions when ownership and possession are separate. If I hire a car, I take possession of the car, but the rental company still owns it. If I lend you a book, then you're in possession of the book, but I still own it. It's very important, before we go any further, for you to have very clearly in your mind the distinction between ownership and possession. The second concept I want you to understand is what we call constructive possession. You see, Australia is an absurdly rich country, and many of us own an awful lot of stuff, far more than we could keep with us at all times. Constructive possession refers to things that we possess even if we don't have them immediately on hand. We possess them because any time we want to, we can go and grab them. And we can also decide whether anyone else is allowed to grab them. So when I leave for work in the morning, I'm still in possession of my TV at home because I can watch it whenever I like, and I can decide who else gets to watch it. With me so far? Now, the torts relating to interference with goods, they protect possession. So the person who was in
not
possession of the goods at the time they were interfered with is the person who brings the action, not the owner.
I wonder why. I wonder why there's that distinction.
It fascinates me that this is still true, even if the person is in wrongful possession of the goods. A person who's in wrongful possession can successfully sue in tort anyone except the rightful owner of the person or a person acting with their authority. So let's say you loaned me your car. And you said, Anthony, get it back by 8 p.m. Friday, please. But I didn't. Saturday afternoon, I still had the car, and so someone else stole it from me from the shopping centre car park. Can you see that they've stolen that car from me?
Okay, I've actually got to go. Hopefully I'll stream later today. Unfortunately, unfortunately I couldn't stream longer. But we're going to finish this off. Hopefully today or tomorrow, we're going to 100% finish this off. And so we're up to 32. Let me stop it here. 32. Great. Okay, this is interesting so far.